Hello and welcome to the Patent Pending Made Simple podcast. I'm Summer Shaw, and on the other line is Jamie Brophy. Jamie, how are you?
Hi, good Summer. How are you?
I am doing well. Glad to be recording again. We haven't quit thus far, so that's a good sign, huh?
Absolutely.
Very good. Well, today's episode is about different types of patent applications that somebody could file. I'm glad to be able to talk about this because there is some confusion when people call our office. They're not sure whether their invention is patentable, and if it is, what kind of patent should they file for? So I think this will be interesting to our listeners here. Jamie, do you want to start us off by maybe talking about the types of patents that are out there that somebody could file for?
Yeah, definitely. The three main types are utility patent applications, plant patent applications, and design patent applications. With the utility application, there's two different types. There's the provisional application and the non-provisional application. The provisional is just an application that is good for a year and it expires after that year. And it's basically just a placeholder for your filing date. And then within that year, on or before the anniversary date of the year, you need to convert that to a non-provisional application. And that's the application that will get examined by the patent office and hopefully end up being a patent.
That's a great overview. Taking a step back beyond that, I think of utility patents as protecting how something works, the underlying mechanism for how something works or how the invention works. I think of the design patent as the ornamental shape or how something looks, being able to protect that. Is that how you would categorize them too, Jamie?
Yeah, definitely. The official definition of a utility application is any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. So that's what's covered in a utility application. So the way something works, the way you make something, things like that. And then for the design application, it basically just covers the way something looks. So it's a lot more narrow coverage in a design patent versus a utility.
Yep, that makes a lot of sense. You had mentioned that the provisional application is only good for 1 year. And I'm going to ask you some questions from the perspective of somebody who has questions about this, Jamie.
Yep.
So, does the provisional application turn into a patent grant?
No, the provisional is, like I said before, just kind of a placeholder for your filing date. You want the provisional application to be as complete as possible. You want it to have everything in it that you think you'll need in your non provisional, but it just sits at the patent office for a year. It doesn't go anywhere. It's a great option for quickly filing something that you need to get protection for. And then it gives you that year to do further inventing or find investors or find manufacturers with the confidence that you do have patent pending status. But no, a provisional application will not be examined by the patent office and it will not result in a patent.
Yep, I agree with that. A lot of attorneys will kind of poo poo or downplay the provisional application. To give you some context, at my old firm, we routinely did not file provisionals at all, mostly because it didn't make economic sense for the law firm. The firm just didn't make a ton of money on those applications. We would file them sometimes if there was an emergency or if there was a on sale bar date coming up or a disclosure date coming up, but normally we wouldn't file them. And a lot of people who actually call our office, they're like, hey, I don't want to file a provisional because I heard they're terrible. And Jamie, what do you think about that? Do you recommend your clients to typically file a provisional, or do you think it's a bad idea to file them?
No, I think it's a good idea to file them, especially for independent inventors, small companies. A lot of times when people come to us, they haven't fully fleshed out what the invention exactly is. They have some ideas for how it's going to work, but they haven't done a prototype. They haven't had engineering drawings done or anything like that. They're nervous about disclosing it to anybody that would need to help them with those things, which makes perfect sense. So I think a provisional is an important step. It gives you some protection while you continue to work on your invention.
Yeah, I agree with that. I think provisionals are great. The challenge with provisionals is that there are very few legal requirements for a provisional application. So you could file theoretically just one sentence about your invention as a provisional application, or a back of a napkin description of your invention and file it as a provisional. I've seen a lot of provisionals like that, and I'm sure other attorneys have seen them as well. I think it'd be easy to conclude from that, hey, provisionals are terrible. They don't give you enough protection. They don't meet the enablement requirement, and so on and so forth. What I like about the way we practice is that we do a pretty good job on the provisional application. They're pretty full featured. They usually always meet the enablement requirements and a lot of other requirements. And Jamie, could you talk about what makes for a good provisional application, or how you think about what needs to go in that provisional application?
Yeah, I mean, I try my best to write the provisional applications in sort of the same manner I would write a non-provisional application. So whatever's in the provisional application is entitled to that filing date of the provisional application. If there's additional things or things that are not disclosed in the provisional that are in the non-provisional, that additional material won't be entitled to the earlier filing date. That's sort of the problem with doing what I like to call a quick and dirty provisional, where you just need to get something filed. You submit just kind of what you have without really writing out a full application. If I have the time, if the client's not in a hurry, I like to write them the same way I would write a non-provisional. Having all the drawings in there to the best of our ability, making sure the invention is enabled, making sure we've disclosed what we think is the best mode of practicing the invention. I would think about what I want in the claims and make sure I disclose those things in the provisional application. So yeah, I try to make it as full of an application as I can, but sometimes it depends on what information the client has and how far they are in the inventing process.
Yeah, that makes sense. You can only protect what the client has invented, but I think it's a mistake. Sometimes inventors think that, oh, well, I can just put anything in that application and file it. And I think that's a pretty big mistake and potentially very dangerous too from a patent perspective. We have rules in the US about statutory bar dates, which essentially refers to your timelines for when you can get a patent. The first requirement is that you have to file a patent within 1 year of your public disclosure date, or the second requirement is that it has to be within 1 year of your sale date. So sometimes this is what happens. Clients will disclose their invention, or they'll sell a prototype to somebody as a way to test their invention. They get close to the 1 year mark and they're like, well, I need to file something and might as well file a provisional just because I don't have the time to put one together, or they want to save some money and try to put it together themselves, or something like that. If you don't meet some of the requirements, or if you don't disclose your invention in sufficient detail to cover that sale or that disclosure, then let's say you file your non-provisional 1 year from that provisional date, that non-provisional application will only get priority to the provisional date to the extent that it's coextensive with the provisional. If it's not, then your own prior disclosure, which would have happened 2 years ago or 2 years from your non-provisional date, would serve to bar you from getting a patent. So if you don't do it right, I think you could open up a trap door for yourself and have your own disclosures invalidate your non-provisional down the road.
Yeah, that's a great point. And there might be a situation where you've made a small change to your invention and you put that in the non-provisional, but it's not in the provisional, so it's not entitled to that earlier filing date, but it could be considered an obvious modification, and you would run into similar issues with that. So yeah, definitely, that's a great point.
Yeah, and this may be beyond the scope of our initial discussion, but if you have a disclosure or a sale before you file a patent, you got to become really careful and vigilant about that first disclosure. And I would circle 1 year from that date on your calendar and make sure that you file a high quality non-provisional from that disclosure date, right? Normally, inventors will file the provisional first and then circle 1 year from the provisional filing date to file the non-provisional. But if the disclosure happened before you file the provisional, then I would key everything off of the disclosure date and not necessarily your provisional filing date.
Yeah, I think that's great advice. And it might be worth talking a little bit about what we mean by public disclosure. I think it's a good practice for any disclosure that you've made, even if you think it is protected under a non-disclosure agreement or something like that, to make sure that you have protection in place within a year of any disclosure. But maybe we should talk about what we mean by public disclosure.
Yeah, I think so. Public disclosure to me is a very complicated topic, and maybe we should have a podcast episode just on that. But from my perspective, there's a lot of gray area in what public disclosure is. The federal courts, especially the federal appeals courts and the Supreme Courts, have not dealt with the public disclosure issue all that often. So there is not a lot of a guideline from the courts about nuances of what constitutes as public disclosure. But there are some bright line rules from my perspective, and this is a very narrow, safe interpretation of the law, is that anytime you disclose something to anyone without a non-disclosure agreement or a confidentiality agreement, that disclosure is considered public disclosure, or at least that's how we should think about it for keying patent deadlines. That means any disclosure you made on social media, or even if it's on a private Facebook group or social media group, if it's a sale or if you sold a prototype, a lot of these things can trigger your public disclosure date and follow on deadlines. Jamie, is that how you think about it as well?
Yeah, I think that's a great general rule to follow. I'll add public disclosure to our list of topics for future podcasts.
Yeah, that's right. I am sure the listeners are going to be waiting. Yeah, and there are a lot of exceptions. So sometimes I've had this several times where people call the office and they're like, well, I disclosed it to my parents. Does that count as public disclosure? Or I disclosed it to my spouse. Does that count as public disclosure? There is a lot of gray area here. And like I said, not a lot of guidance from the courts about these things. So there has been no Supreme Court or a Federal Circuit opinion about whether disclosing something to your parents would count. But I would say that, if you don't have an NDA, be on the safe side and think of it as a public disclosure.
Yeah, make your parents sign an NDA.
Yes, this is what lawyers are for.
Right. So, okay, I think that covers utility applications. And, utility to me incorporates provisional and non-provisional. We could talk a little bit about design patents. We already touched on that. A design patent would just cover the way something looks. There is no option for a provisional for design applications. A design application can claim priority to a non-provisional, but it can't claim priority to a provisional. So if you have a new ornamental design for how something looks, a design patent would be for you. Do you have anything to add, Summer, about design applications?
No, I think that's good. If you have made a public disclosure and if you think your invention might be a design patent, you need to be really careful when you start thinking about putting a provisional together. Because we've actually had this. We had clients who have filed their own provisionals. They wait a year to contact us, and then they're like, hey, I want to file a design patent. But if you made a disclosure prior to that, 1 year filing bar date, you may be out of luck, right? A design patent application may not be a viable option for you anymore. So there is that extra consideration that you should think about if you think your invention would qualify as a design application.
Yeah, that's a great point. Or maybe they filed a provisional thinking they're going to go for a utility. We do a patentability opinion and discover it's probably not patentable. And they say, well, maybe I can do a design application. And we think that that might be a good option for them. But it's approaching that 1 year public disclosure on sale bar date. So that could be an issue. Also something to think about.
Yeah, I agree. I wonder if we are being a little too theoretical and abstract for our audience. Jamie, do you want to maybe together go through some examples of things that you would consider utility patents and design patents? For example, I'll start us off. If a client has invented a fidget spinner toy, what would you recommend? Would that be a utility or a design patent to you?
Off the top of my head, I'm thinking it'd probably be a design patent because fidget spinners are known. If they came up with a new shape for it or a new way that it looks, that it'd probably be a design patent, unless, it spins in a new and unique way or something like that. But yeah, to me, that sounds like a design patent.
Yeah, I would agree with that. I mean, if you have designed a new mechanism for how it spins, or if it has gears or differential torque ratios or something like that, then yeah, that would be a utility patent. But if it's just the way it looks, I think that would be a design patent. So I'd agree with that. What about if somebody has invented a new shape of a hammer that's more ergonomic?
Yeah, design patent. What do you think?
Yeah, I would agree. I mean, hammers have been known for centuries. So yeah, I don't think that would fall under utility. It would just be the shape of the hammer. So that would be a design application to me.
Yeah, definitely.
What about situations where somebody's invention can fall under both a utility and a design patent application? What kind of advice would you give to an inventor who's in those shoes?
I would suggest applying for both. You never know what's going to happen in the patent prosecution process. So, my preference would be to file both and to file them on the same day or approximately the same day. If budget allows, I would apply for both.
Yeah, I agree. If budget allows, I would do both. If you only have budget for one application, the question that I like to ask clients is, what would you be most upset about if you found somebody copying either the utility or the functionality of the invention or the shape of the invention? Which one would upset you the most? That's usually a good starting point for figuring out what might be most important. Also, think about whether copying the utility or the design would allow somebody to create a competitive product, and whether that competitive product would be suboptimal in many ways, right? If it's not as attractive, then that's also a good way to kind of prioritize these filings. Anything else that you would think about, Jamie?
No, I think that's a great way of looking at it. Yeah, I think that's great advice.
Okay, great. So I think we've covered those. We have plant patents, which I don't have much to say about, Jamie. What do you know about plant patents?
Not much. And, 23, 24 years of experience. I don't think I've ever seen a plant patent. I've definitely never worked on one. If you come up with a new plant, then you would want to get a plant patent on it, but I've never done them personally.
Yeah, me neither. I know they theoretically exist, but I've never seen them. So
Yeah.
somebody has a bunch of plant patents, and maybe we'll interview them one day. I think this is great. There's also the PCT application. Maybe we should talk about that. I'm sure some of the listeners will have questions about protecting their invention internationally, and maybe they've heard of the term PCT. Could you explain what that means?
Yeah. So PCT stands for Patent Cooperation Treaty. And this is a treaty amongst a bunch of different countries. If you're interested in protection outside of the US, you'd file one PCT application, and then within a preset time limit, maybe you can talk more about the time limit, Summer, but within a preset time limit, you would need to decide which countries you want to go into from the PCT. If you decide you want protection in Europe, Europe is all one patent office covers all of Europe. So European protection, protection in Japan, and protection in China. You could then branch off of your PCT application and file in all these different countries. Does that about cover it?
Yeah, I think that's right. So, from a timing perspective, you do have 1 year from your US application, your first US application, to file the PCT application. So, that deadline could be triggered by a provisional or non provisional, whichever one comes first, essentially. So, you do have 12 months from your US application filing date to file the PCT. And then the PCT application will give you another 18 to 30 months to make a decision on which country you want to file in. So the way it works is you get 30 months if you file the PCT as your first application, or 30 months from your first priority application. So let's say you file the provisional first, you would have 30 months from that provisional filing date to make a decision on whether to file internationally or not. So in effect, the way it works for most clients who will file a PCT, they'll file the provisional, 12 months later, they'll file the PCT, and then 18 months after that, they'll have to make a decision on which countries they want protection. And that process going into each country is called the national phase entry process. And most countries will have their own deadlines about when that national phase entry has to happen. Some countries are as short as 20 months, 18 months. Most countries fall at the 30-month deadline, and then a few countries also fall under the 32-month deadline. I don't think any go past that. So maybe I should talk about some costs just so people have an idea. The PCT filing itself is $1,000 to $2,000, depending on if you're a micro entity or a small entity. It's not super expensive at that stage, and usually you would want to file the same document that you filed in the US at the PCT. You had to reformat it and file some additional paperwork with it, but the content of the application, at least when we do it, is the same in the US and the PCT. After that, when you go into national phase entry is usually when the process gets very expensive. You have to hire lawyers in each individual country that you want protection in. So if you work with us, for example, we have connections with a lot of foreign counsels, so you don't have to worry about that. But if you're going to do it on your own, you would have to find an attorney in that country to do the national phase entry. And in my experience, it ends up being about $4,000 or so per country if it doesn't require a translation. If it requires a translation, like in the Japanese patent office or the Korean patent office, it's another 2 to 3K for the translation process as well. And then if you wanted to file the EPO, the European Patent Office, it's usually $6,000 to $8,000. But that would give you coverage over all the European countries as opposed to going to the European countries individually. So that's when the process gets expensive. If you're in 10 countries, you can very easily spend 60, 70K in that process. So that's something you want to think about. That process gets pretty expensive pretty fast.
Yeah, definitely. Luckily, your U.S. patent protects you from anything being imported, but unfortunately, it doesn't offer you any protection in other countries. So yeah, if you plan on selling in other countries, PCT would definitely be the way to go. But I have a question for you about PCTs, Summer. Is it possible for somebody to file a provisional in the U.S. and then file the PCT application 12 months later and then enter the U.S. during the national phase entry?
Yeah, absolutely. You can do that. I had somebody call my office and they said, U.S. applications have a filing fee. So they were like, can we just skip the U.S. provisional and just file a PCT from the get-go? And then you have 30 months from that date to do a national phase entry in the US. So theoretically, that's possible. Not just theoretically, it's definitely possible for you to enter national phase in the US through the PCT. So it could buy you some extra time.
Okay. Yeah, good to know. And then when you say it costs $1,000 to $2,000 to file, that's just the filing fee, correct?
That's the filing fee. For us, we don't charge additional attorney's fees. We do charge a paralegal fee for our paralegals to file the application, but usually we don't charge an additional attorney's fees because we just file the same document that we filed at the US application at the PCT level as well.
Great. Okay. Yeah, I think that covers it for PCTs. Do you have anything else to add?
No, I think this is it. I feel like we threw a lot of information at the listeners. So hopefully everyone stuck around till the end and hopefully found this informative and helpful.
Yeah, definitely. All right. Thanks, Summer.
All right. Yeah, thanks, Jamie. Thanks, everyone, for listening. We'll be back with our next episode next time. Thank you for joining us on the Patent Pending Made Simple podcast. I hope you enjoyed our show. If you'd like to receive updates, view the show notes, or access a direct link to any resource, go to the episodes page on patentpendingmadesimple.com. To help others find our podcast, please like, share, and subscribe. Thanks again for tuning in. I look forward to having you with us next time on Patent Pending Made Simple. This podcast has been hosted by Outlier Patent Attorneys and is not intended to, nor does it create, the attorney-client privilege between our host, guest, or any listener for any reason. The content of this podcast should not be interpreted as legal advice. All thoughts and opinions expressed herein are only those from which they came.